Oh, this one is hello, hello, hello. Testing 1 2. Testing.
Okay. One, two, one, two.
Prayer.
Almighty God, who in your wisdom and goodness has appointed the offices of leaders and parliaments for the welfare of society, good of all human lives upon it, and the just government of its people. We beseech you to look with your abundant favor upon us, your servants, whom you have entrusted with the performance of such important trust in this community. Let your blessings descend upon us here assembled, and grant that we may treat and consider all matters that shall come under our attention and deliberation in so just and faithful a manner as to promote your honor and glory, and to advance the peace, prosperity, and welfare of this region and of those whose interests you have committed to us. Amen.
Item number 1 on order paper, communication from the chair.
Good morning, honorable members. Good morning, honorable members. Thank you. So, because we have been together here for some time, we have interacted, and I may not have much to announce, but I hope we all had a good recess. And while we were away, that's when one of our own staff, Ms. Maria Ruhere, passed on. I thank you for the support you extended to the family then, and those who joined me to attend her burial. We also have a colleague who lost her mom, Honorable Moma Mo. We have Honorable Leontine lost a relative, a close relative. I think several relatives actually. We have staff who lost their parents. So all those, we pray for them. And because we are meeting for the first time after those unfortunate events, we request you that we rise for a minute and pray for the departed ones. May their souls rest in eternal peace. Thank you.
Item number 2 on the order papers, starting with Roman 1.
Chairperson, Committee on Legal Rules and Privileges. Is the chair okay? Please proceed, Honorable Mukuri. You read before? Let me be guided properly. I'm sorry about that. Honorable Chair, I'm told the report you laid had an error that has ever been corrected. So maybe you can lay it again, the corrected report.
Thank you so much, Right Honorable Speaker. Right Honorable Speaker, I beg to lay on the table the report of the Committee on Legal Rules and Privilege on the oversight activity of the development of the legal sector in the community. I beg to lay.
Still under the same item, Roman 2.
Chairperson, Committee on Regional Affairs and Conflict Resolution. The microphone.
Right Honorable Speaker, I beg to lay the report on oversight activity by the Committee on Regional Affairs and Conflict Resolution on the progress made and challenges faced by EAC in implementing the regional peace and security strategy. I beg to lay.
Still under the same item, Roman 3.
Honorable Ambassador, if you can switch off your microphone. So Roman 3 is supposed to be handled by the Chair Council of Ministers, but I'm told the Council Chair is still on his way, so he's not yet here. We shall skip that item.
Item number 3, report of the Committee on Legal Rules and Privileges on the oversight activity on the development of the legal sector and the EAC by way of motion.
Honorable Speaker, I beg to move the motion that the report of the Committee on Legal Rules and Privileges on the oversight activity on the development of the legal sector in the East African community be adopted. I beg to move.
Seconders, Honorable Rutazana, Honorable Victor, Honorable Simon Mbugua, Honorable Francoise Bahati, Honorable Karinda, Honorable Thomas Duty, and all members standing. Honorable Chair. Proceed and present the report, and you can use the podium if you wish.
Thank you, Right Honorable Speaker and honorable members. Let's go to introduction. Article 126 of the treaty for the establishment of the East African community provide that in order to promote the achievement of the objectives of the community, as set out in Article 5 of the treaty, the partner states shall take steps to harmonize their legal training and certification, and shall encourage the standardization of the judgments of courts within the community. For purposes of this article, the partner states shall, through their appropriate national institutions, take all necessary steps to A, establish a common syllabus for the training of lawyers and a common standard to be attained in examinations in order to qualify and to be licensed to practice as an advocate in the respective superior courts. B, harmonize all their national laws appertaining to their community. And C, revive the publication of the East African law reports or publish similar law reports and such laws journal as will promote the exchange of legal judicial knowledge and enhance the approximation and harmonization of legal training and the standardization of judgments of courts within the community. Likewise, Article 9 of the treaty established several organs and institutions of the community, one of them being the East African Court of Justice, which is the judicial organ of the community. One of the cardinal functions of the East Africa Legislative Assembly is to conduct oversight activities on programs and activities undertaken by organs and institutions of the community. It is against the above introduction that the Committee on Legal Rules and Privileges of the East African Legislative Assembly conducted an oversight activity on the development of the legal sector of the community. This activity took place virtually from 21st to 24th of February 2021. The objectives of the activity, the main objectives of these activities were: 1, to assess the development of the legal sector in the community; 2, to assess the activities of the East African Court of Justice; and 3, to prepare recommendation on what to be done to enhance, promote the legal sector in the EAC. Methodology. The committee conducted interactive meeting virtually through Microsoft Teams to engage the following key stakeholders: the East African Court of Justice, and that is represented by the Registrar of the East African Court of Justice; the East African Law Society; the Office of the Counsel to the Community, CTC. 4, presentation from the East African Court of Justice. Establishment of the East African Court of Justice. The East African Court of Justice is the judicial organ of the EAC established under Article 9 of the treaty. Then the whole of Chapter 8 of the treaty is dedicated to the court. The East African Court of Justice was established to ensure adherence to law in the interpretation and application of and compliance with the treaty. Article 23 of the treaty sets out the expected responsibilities of the court and creates the two divisions of the court, namely the first instance division and the appellate division. Article 24 of the treaty spells the appointment of the judges of the court and the designation of the president of the court and the principal judge. Article 25 provides for the tenure of the office of the judges. Judges serve the court for a term of 7 years, but they can exit before they say tenure once they reach 70 years of age. Experience shows that the same judges serve the court for a period of between 4 to 5 years and forced to exit the court because of their age. It would boost the jurisprudence of the court if all judges shall serve the court for 7 years tenure. Jurisdiction of the East African Court of Justice.
Jurisdiction.
Yes, sub-article 1 of the treaty, sub-article 1 of Article 27 of the treaty provides for the initial jurisdiction of the court, which is limited to interpretation and application of the treaty. Sub-article 2 of the same article empowers the Council of Ministers to extend the jurisdiction of the court to include other areas, including areas that the court will have original jurisdiction. Appellate jurisdiction and human rights. The treaty, however, states that the court's jurisdiction to interpret the treaty shall not include application of any such interpretation to jurisdiction conferred by the treaty on organs of partner states. However, the treaty does not mention the matters conferred to the jurisdiction of organs of the partner state for the purpose of clarity. It is important for the community to review Article 27 of the treaty. On the issue of extending the jurisdiction of the East African Court of Justice, the meeting of the Sectoral Council on Legal and Judicial Affairs held on the 24th of November 24 observed that there is need to extend the jurisdiction of the court. Following that observation, the East African Community Secretariat prepared a zero-draft protocol to extend the jurisdiction of the court and submitted it to the meeting of the Sectoral Council on Legal and Judicial Affairs held on 8th of July 2005. The Sectoral Council adopted the zero draft and subjected it to wider consultative process. Despite the draft protocol being considered by several meetings of the Sectoral Council on Legal and Judicial Affairs and the Council of Ministers, the jurisdiction of the East African Court of Justice is not yet extended to date. In summary, the East African Court of Justice have jurisdiction over the following areas: dispute on interpretation and application of the treaty, disputes between the community and its employees arising from the terms and conditions of employment or the interpretation and application of the staff rules and regulations, disputes between the partner states regarding the treaty if the dispute is submitted to it under special arrangement, disputes arising out of an arbitration clause contained in a contract or an agreement which confers such jurisdiction on the court to which the community or any of its institution is a party, disputes arising out of an arbitration clause contained in a commercial contract or an agreement in which the parties have conferred jurisdiction on the court, and provision of advisory opinions. Access to the East African Court of Justice. According to the treaty, the East African Court of Justice is open to partner states, the Secretary General, the Summit, the Council, employees of the community, and private litigants, legal and natural persons residing in the East African community. The partner states have undertaken another partner state to East African Court of Justice so far. I mean, no partner state have taken another partner state to the East African Court of Justice so far. However, a partner state sued the Secretary General on the matter of the election of the Speaker of EALA. The Secretary General is empowered to sue partner states where they fail to fulfill their obligation under the treaty or for the violation of the provisions of the treaty. There has been a number of instances where the Secretary General will have sued partner states. However, the cumbersome procedure provided by the treaty have been a hindrance to the Secretary General to take a partner state to the East African Court of Justice. Private individuals who want to file a case at the East African Court of Justice faces two serious obstacles created by Article 30 of the treaty. One, the person must be a resident in a partner state. In one case, a Burundian citizen lost a case merely because he stated that he resides in the United States of America, withstanding the fact that he owns properties and pays taxes on his properties in Burundi. Two, the suit must be filed within 2 months from the occurrence of the action complained of. This is a very short time for a regional court. Worse enough, the limitation applies only to individuals, excluding other litigants at the court, which is an act of discrimination. The court does not charge filing fees for all cases except only for arbitration matters. Relationship between the Court of Justice and the national courts. The East African Court of Justice and national courts of the partner states relate on the following matters: existence of concurrent jurisdiction on the interpretation of the treaty. This means that even a national court can determine a case canvassing on provisions of the treaty. Article 34 of the treaty allows the East African Court of Justice to give preliminary rulings on questions pending in national courts upon request by the national courts themselves. National courts houses free of charge the East African Court of Justice sub-registries in their respective partner states. Most of the judges at the East African Court of Justice are appointed from the national courts and continue to serve both the East African Court of Justice and the national courts. Development facing the East Africa Court of Justice. Development and challenges facing the East African Court of Justice. In 2015, the Council approved and granted financial and administrative autonomy to the East African Court of Justice and EALA. However, the operationalization of that decision has been shrouded in mystery. To implement the decisions, the Office of the Registrar of the East African Court of Justice and the Office of the Clerk of the East African Legislative Assembly prepared a detailed document showing the roadmap of implementing the decision. Part of the roadmap was to implement immediately matters that do not require amendment of the treaty, while the long term was to await the amendment of the treaty. The Council considered the draft roadmap and referred to the Council to the community for clarification and recommendation. The CTC reported back to the Council, which after considering the comments of the CTC, requested for further clarification from the CTC. The CTC has not submitted the second clarification requested by the Council. Another challenge is the issue of upgrading the Clerk of the Assembly and the Registrar of the Court from professional level 5 to executive level 1. That is P5 to D1. A process that started in 2015. The agenda was to upgrade the Council to the community, the Registrar, and the Clerk. However, the CTC was upgraded. There was no reason recorded for not upgrading the other two positions, and in a number of occasions, the Secretary General explained that the Council upgraded all the three offices. For example, the SG informed the Assembly that the Council upgraded all the three positions. It is important to note that the Registrar of the East African Court of Justice and the Clerk of the East African Legislative Assembly are created by the treaty like the office of the CTC. It is therefore unrealistic to equate the Registrar and the Clerk with other directors in the Secretariat, while heads of institutions are positioned at the executive level 1. The Registrar and the Clerk hold a sub-accounting responsibility, which include financial, administrative, and their professional relating to the work of the relevant organs. The third serious challenge facing the court is the non-implementation of Article 45(2) of the treaty, which empowers the court to employ some of its staff as may be required to enable it to perform its function. To the contrary, the recruitment of staff for all organs and institutions of the community is controlled by the Secretariat. This includes even staff that does not require approval of the Council of Ministers. To address some of the challenges facing the court, the East African Legislative Assembly, through a private members bill, passed the administration of the East African Court of Justice bill. The bill is still undergoing the assent process, which has taken so long time. The fourth challenge facing the court is the ad hoc nature of the service of the judges. Sub-Article 4 of Article 140 provides that during the transition period, judges appointed to serve the court will be on an ad hoc basis until the court is fully operational at the time to be determined by the Council of Ministers. Interestingly, all transition provisions provided by Article 140 have been actualized except the one for the court. The court, which is inaugurated in 2001, has been operating on an ad hoc basis for 20 years. In an attempt to end the transition period, the court prepared a background paper for the council to consider and approve. The paper highlighted the cost benefits of having permanent judges sitting in Arusha. The council is yet to decide on this matter. Implementation of judgments delivered by the East African Court of Justice. All international courts do not have their own mechanism for execution of their judgments. The court therefore only rely on the goodwill of the partner states to implement these judgments. More often, that it is not easy. Implementation of judgments will not be a matter of the goodwill of their partner state, but a matter of the rule of law and good governance. Once East African Court of Justice has delivered a judgment, it becomes difficult to know if it has been implemented or not. In a few instances, the beneficiaries of those judgments have come back to the court to sue against the partner state that has not implemented the previous judgment. Article 38.3 provides that a partner state or the council shall take without delay the measures required to implement a judgment of the court. It is therefore a requirement of the law for the partner state and the council to implement judgments of the court. Failure to execute judgment of the East African Court of Justice becomes a violation of the treaty on both Article 38.3 and Article 6D as a violation of the rules of the rule of the law. However, the provisions seem to put the burden of implementing a judgment of the court on the partner states and the council only, leaving out other organs and institutions of the community and individuals who are sued at the court. It is imperative, therefore, that the requirements to implement decisions of the court be extended to all persons that may be sued at the East African Court of Justice. Proposal on how EALA can support the activities of the East African Court of Justice. The East African Court of Justice requires the Assembly to support the functions of the court by, one, urging the Council to conclude the granting of financial and administrative autonomy to the Assembly and the court. Two, urging the Council to push for the assent of the administration of the East African Court of Justice Bill. Three, urging the Council to direct the implementation of Article 45.2 of the treaty to allow the East African Court of Justice to handle recruitment of its staff and to handle the recruitment of its staff that do not need the approval of the Council. And four, urging the Council to initiate the process of amending the treaty in order to address some of the challenges that are hindering the smooth operation of the East African Court of Justice and other organs and institutions of the community, of which we have Annex E that contains the proposal for the amendment of the treaty for the East African Court of Justice. 5, presentation from the East African Law Society. The East African Law Society is the umbrella regional bar association of East Africa, a dual membership organization bringing individual lawyers members as well as 7 national law societies. The 7 law societies are the Burundi Bar Association, the Law Society of Kenya, the Rwanda Bar Association, the Tanganyika Law Society, the Uganda Law Society, the Zanzibar Law Society, and recently the South Sudan Bar Association. The East African Law Society focuses on 3 areas: promoting regional integration, providing professional development services to its membership, and promoting constitutionalism, democracy, good governance, rule of law, and advancement, promotion, and protection of human rights in East Africa. The history of the East African Law Society. The East African Law Society was born out of a challenge that the East African lawyers got when they attended the United States State Department sponsored study tour of the African legal practitioners from 40 countries in Washington, D.C. in 1995. During the session, it was apparent that lawyers from the other economic blocs were organized in a regional bar association, while those in East Africa had none. Thereafter, the lawyers who attended the conference in the United States of America drafted a constitution for the society. The aim was to register a regional body. However, at the time, the governance system was very restrictive, and the only way to register was a company limited by guarantee. The East African Law Society was registered in Tanzania on 26 October 1995 as a company limited by guarantee and registered as a foreign company in Kenya and Uganda. 4 years later, the East African Law Society managed to set up a secretariat in Arusha at the Arusha International Conference Center. The East African Law Society was reorganized in the year 2000 under a new strategic plan. Since then, the East African Law Society has grown in heaps and bounds to become the largest organized professional membership organization in East Africa, with more than 18,000 members and a strong mandate and interest in the practice and professional development of law, as well as people-centered regional integration process. The society has built a reputation for taking a stand against constitutional violation and has entrenched its position as a force in the rise of constitutionalism, democracy, good governance, as well as the rule of law and advancement, promotion, and protection of human rights in East Africa and beyond. In 2013, members passed a resolution to amend the memorandum and articles of association to reflect the entry of the Republic of Burundi and the Republic of Rwanda into membership of the East African Law Society, and also inserted an affirmative action clause on gender representation, as well as affirming the ownership of the society by the members. Observer status and membership of the East African Law Society to the international forums. The East African Law Society was granted observer status with the East African community, which paved a way for the society to interact with the organs and institutions of the community. The East African Law Society also holds an observer status with the African Commission on Human and People's Rights, and it is a founding member of the UN International Coalition on the Responsibility to Protect, which is ICRTOP, based in New York, as well as the African Court Coalition. Membership of EALS. The membership of the East African Law Society includes both institutional and individual members. Institutional members are the guarantors of the East African Law Society Constitution and include the 7 national bar associations in the EAC. The national law societies from the national level offices of EALS. Individual membership entails all practicing advocates across the region, now numbering over 18,000. The achievement of the Law Society. The society has been able to regularly bring together its more than 18,000 advocates to discuss issues facing the profession and region, to network and build partnership in many ways to support the integration narrative. The society has been able to consistently build the capacity of its members, giving them a competitive edge and ability to compete with their peers from across the globe. Recently, the society launched its independent training vehicle, the East African Law Society Institute. The society has made critical inputs to the regional integration process, supporting numerous initiatives aimed at spurring and enhancing the regional integration process. This initiative range from the direct support of the East African Court of Justice institution, the East African Community institution, such as the East African Court of Justice, the Secretariat, and even the East African Legislative Assembly. Support in the policy-making process, support in law-making process, inputs into various bills, especially private members' bills. The society has regularly played mediator in cases of conflicts among partner states and has in many ways support full implementation of the East African Community Treaty and attendant protocols and law. The society has taken this role and ensured respect for rule of law, good governance, and respect for human rights. Through high-level advocacy, strategic litigation, and other actions, the society has managed to keep governments in the EAC in check. The society has consistently promoted scholarship, regularly producing several high-caliber publications, including journals, magazines, and bulletins, and even law reports, this focusing on the East African Court of Justice. The society has also acquired permanent office premises in Arusha, Tanzania. Challenges facing the society. Non-commitment by EAC leadership to operationalize cross-border legal practice. 2, lack of harmony in judicial and legal processes across the region. 3, lack of uniformity in the training of legal professions across the region. 4, non-harmonization of laws by EAC partner states. 5, failure to implement court decision, politicians, public statements calling for the disregard of the court orders. Escalation of affronts to the independence of the legal professionals, regular search, arrest, and detention of lawyers department. Increasing nationalism, lack of quorum at the regional court, and use of repressive laws to stifle functions of law society. Opinions of the East African Law Society on the development of the legal sector in the East African community. The East African Law Society was one of the opinion that the stakeholders, partner states, and the East African community have failed to implement key provisions of the treaty that will lead to sustained development of the legal sector. The lack of enabling instruments and the lack of goodwill to create them have crippled development of the sector, with most of the efforts in the area being from the private sector. The key areas that have failed to kick off and that needs urgent action include enacting a law governing the cross-border legal practice in the EAC, or a law to empower the East African Law Society to monitor and supervise the conduct of cross-border practice. And this is provided for under Article 126, Article 76, and Article 10 and 11 of the Common Market Protocol. Implementation of the East African Community Common Market, mutual recognition of academic and professional qualification, Regulations 2011, this will have paved way for the mutual recognition agreement. Harmonization of legal training curriculum in the region. While the East African Law Society has come into breach the existing legal gaps, a lot still needs to be done to ensure the legal profession grows at the same pace as the integration process. How to support the activities of the East African Law Society and lawyers in EAC. 1, support the drafting and passing of the East African Community Cross-Border Legal Practice Bill, or a law to empower East African Law Society to monitor and supervise the activities of lawyers in cross-border business. 2, urge the Council of Ministers to implement Article 126 and Article 76 of the treaty, as well as Article 10 and 11 of the Common Market Protocol. 3, urge the Council of Ministers to support the signing of the Advocate Mutual Recognition Agreement. 4, urge the Council of Ministers to support the harmonization of laws in various matters across the region and fervently ensure they are implemented. Urge the Council of Ministers to continue with the publication of various legal instruments and documents, including the East African law reports. 6, urge the Council of Ministers to extend the jurisdiction of the East African Court of Justice to include human rights and other matters, and appoint judges of the East African Court of Justice. 7, urge the Council of Ministers to create a legal regime for registration of regional entities to reduce control by partner states. And 8, support good governance and democratic tolerance across the East African community. Meeting with the Council to the community. The committee interacted with Dennis Kibirije, the principal legislative draftsman, on behalf of the Council to the community to discuss on some issues raised during that activity. Mr. Kibirije informed the committee that the Sectoral Council on Legal and Judicial Affairs will take place in May 2021 to deliberate various issues relating to the legal sector. He promised that during the meeting, various stakeholders, including the Committee on Legal Rules and Privilege and the President of the East African Court of Justice, will be invited to engage with the Sectoral Council. One of the obstacles to the process of amendments of the treaty is inadequate financing of the legal sector in the community. The process needs intensive research in order to come up with workable recommendation, because amendments of the treaty should be taken serious as amendment of partner states' constitutions. Organs, institutions, and individuals that wish to propose amendment of the treaty should submit their proposal to the Secretary General, who will then table those proposals before the Council, which once adopted, they will be considered and proposals by the Council of Ministers as per Article 150 of the treaty. Observation of the committee. There is need for the community to develop regulations on the appointment of judges at the East African Court of Justice that will ensure judges appointed will serve for the entire tenure of 7 years. There is a need for the treaty to mention or clarify the matters conferred to the jurisdiction of organs of the partner states, and specifically mention the state organs. The process to assent the administration of the East African Court of Justice Bill, which was passed by EALA in January 2017, has taken a too long period. It is time for the East African Court of Justice to be fully operationalized by the Council of Ministers. The position of the Registrar of the East African Court of Justice and that of the Clerk of the East African Legislative Assembly should be upgraded to Executive Level 1. The jurisdiction of the East African Court of Justice need to be extended as it was envisaged by Article 27 of the treaty. Citizens of the partner states should be given the rights to file cases at the East African Court of Justice, regardless of wherever they reside. The period of filing cases at the East African Court of Justice by individuals need to be extended to give them enough time to prepare their cases before filing them at the court. The East African Court of Justice and the East African Legislative Assembly need to have financial and administrative autonomy. The East African Law Society and other stakeholders in the legal sector should be given more time to engage with the organs and institutions of the community. Article 126 and 27 of the treaty, as well as Article 1011 of the Common Market Protocol, should be fully implemented by relevant stakeholders, and the harmonization of national laws appertaining to the community is one of the key steps in the development of the legal sector in the community. The Committee on Legal Rules and Privileges therefore recommends to the Assembly to urge the Council of Ministers, 1, to develop and adapt the regulations or guidelines on the appointment of judges at the East African Court of Justice that will ensure judges appointed will serve for the entire tenure of 7 years. Initiate comprehensive amendment of the treaty to address all issues raised in the report and the recommendation made by organs, institutions, and individuals with regard to various provisions of the treaty. Follow up the assent of the administration of the East African Court of Justice Bill and all other bills that are awaiting assent by the heads of states. Extend the jurisdiction of the East African Court of Justice by finalizing the protocol on the extension of the jurisdiction of the East African Court of Justice. Fully operationalize the East African Court of Justice as per Article 140 of the treaty. Upgrade the position of the Registrar of the East African Court of Justice and the Clerk of the East African Legislative Assembly from P5 to P5 to D1. Finalize the process of granting the East African Court of Justice and the East African Legislative Assembly the financial and administrative autonomy on matters that does not require amendment of the treaty while awaiting the amendment of the treaty. Prepare a bill to govern the cross-border legal practice in the East African community. Fully implement Article 126 and 76 of the treaty, as well as Article 10 and 11 of the Common Market Protocol. And lastly, fast-track the harmonization of all national laws appertaining to the community. I thank you, right honorable speakers and members for listening.
Thank you. If you can switch off the microphone, Honorable Chair. Thank you very much, Honorable Kennedy Mukuria. Honorable members, the motion before the House is that the report of the Committee on Legal Rules and Privileges on the oversight activity on the development of legal sector in the EAC be adopted. Debate is open. Honorable Dr. Makame.
Thank you very much, Mr. Speaker. Thank you for welcoming us back after the recess. And I'd like to commend my brother, the chairperson of the Committee on Legal Rules and Privileges, for a detailed report on an oversight activity, and the members. I see the report has done justice to the area, but I have a few comments, and I believe the mover of the motion would take them on board and consider also accommodating them while finalizing the report. Particularly, Mr. Chairman, Mr. Speaker, my issue was on section 5.5 on page 12, Roman 1. It says non-commitment by EAC leadership to operationalize cross-border legal practice. Mr. Chairman, Mr. Speaker, sorry. The issue of cross-border legal practice, I think it's an issue which is meant to be decided upon by the bar associations, but will ultimately come to the Secretary Council on Legal and Judicial Affairs for further before to be considered by the Council. But the report also quotes Article 76 of the treaty. Mr. Speaker, if you allow me to just open and read it out so that we are all on the same page. And on Article 76, which says establishment of the common market. And Article 76(2), it reads, it says, the establishment of common market shall be progressive and in accordance with schedules approved by the Council. So what I'm trying to raise here, Mr. Speaker, is that there are some countries in the East African community that have committed legal practice to the common market. And there are some other countries that have still reserved the practice of the legal practice. So that does not violate the treaty. Until and when those the legal practice is committed as per the in accordance with the schedules that will be approved by the Council. And that is why, Mr. Speaker, if you recall, and this House will recall, on 5th of December 2019, I moved a motion before this August House, and the motion was adopted that the Council of Ministers should be updating this House regularly on implementation of various pillars of the treaty, including, but are not limited to, decisions of the summit and decisions of the Council. Mr. Speaker, that motion, after being adopted, much as the motions of the House have no legal binding, but we understand that we have goodwill with our colleagues, and the organ who also happen to sit in here as ex officials, the Council, and the main reason why we are working together is we are trying to progress the integration forward. So at least we should have seen the council coming with a report so that they would be engaging the sectors in the partner states to track the implementation of the integration. We don't want to just be talking and not working. We want to have results. So, Mr. Speaker, accordingly, Mr. Speaker, and after we look at that Roman 1, and we looked at Article 76(2) of the treaty. Now, if we look at Article 76(3) of the same treaty, on the same area, it says, for the purpose of this article, the council may establish and confer powers and authority upon such institutions as it may deem necessary to administer the common market. Mr. Speaker, I'm not saying, or I'm not trying to say that the council are not implementing the common market. They are. The council is implementing, supervising the implementation of the common market. But we are now on the third stage, because the first stage is the customs union, the second stage is the common market, the third stage is monetary union, but we are seeing still the first stage is yet to be fully implemented. The second stage also we are just touching here and there. The third stage, I'm not sure whether we are going to implement it, but this provision, Article 76(3), provides for the council to establish an institution that would assist in implementation of the common market. And that, because I mean, when this is in the treaty, so probably the council might also want to consider implementation of Article 76(3). Mr. Speaker, elsewhere on the same item 5.5, Roman 5, it reads failure to implement court decisions. Politicians' public statements calling for disregard of court orders. Mr. Speaker, that one does not sound very well. That one does not sound very well, and Mr. Speaker, if there are politicians and who are doing that, maybe it would have been right to capture them and maybe to see what could be legal action could be taken. I mean, because we know that court orders have to be implemented. Now, if I'm not sure whether there will be a politician with such an impunity of making public statements that court orders should not be implemented. If that is the case, then maybe we should be informed so that we know, and maybe we can have a resolution to that effect. Mr. Speaker, on page 13, Roman 1, it is enacting a law governing cross-border legal practice in the EAC, or a law to empower East African Law Society to monitor and supervise the conduct of cross-border practice. Article 126, Article 76, Article 10, and Article 11 of the Common Market Protocol. Mr. Speaker, here again, I had already indicated while I was commenting on 5.5 Roman 1, because we spoke about, I spoke about 76(2) and 76(3), which I want to repeat. But in the common market, the Article 10 speaks about the free movement of workers. And those ones, the free movement of workers would only be, again, according to the committed schedules, and those schedules that the ministers have agreed in the council. So I'm not sure whether this would apply at this stage. And also in the Article 11, it is an issue of harmonization and mutual recognition of academic and professional qualifications, which also has a bearing on the issue of committed schedule. So, Mr. Speaker, to conclude, I would really say that I'm in support of the report, but I would really request my brother, the chair of the Legal Rules and Privileges Committee, to consider these comments, factor them, and also to amend the recommendations such that we would require the council also to be regularly reporting the issue of the implementation of the common market, customs union, also monetary union, the issue of council decisions, summit decisions. We have been informed and we are aware that there are decisions which are taken and are not implemented, and that, Mr. Speaker, does not keep us in a very good picture. Other than that, Mr. Speaker, I beg to support the report. Thank you.
Thank you, Honorable Dr. Makame. So Honorable Gabriel Alak, Honorable Wanjiku.
Thank you, Mr. Speaker. Let me commend the good work that has been done by the Committee on Legal Rules and Privileges, the presentation that has been made by the chair. I rise really to be precise a point. Article 27 of the treaty provides for the initial jurisdiction of the court, which is only limited to interpretation and application. But sub-article 2 of the same article empowers the council to extend the jurisdiction of the court to include other areas that will have original jurisdiction, appellate jurisdiction, and human rights. It was good that the Secretarial Council adopted a zero drop, and also the council for the extension of the jurisdiction of the court. I'm wondering why is this such a delay? And this thing was done as far back as 2004. Our cases are being referred to the ICC for human rights violations in some of our countries. Then why would we be dragging our feet in not really trying to extend the jurisdiction of the court so that some of the issues connected with human rights abuses in our partner states are also handled by this court? So I'm really emphasizing number 4 recommendation of the committee, which says that to extend the jurisdiction of the East African Court of Justice by finalizing the protocol on the extension of the jurisdiction of the East African Court of Justice. Because I'm wondering, what is the cause of the delay? If our countries can be members of the ICC and we try to cooperate with the ICC, why would we not establish this by extending the jurisdiction of the court so that we settle some of the issues here in this court? So, Mr. Speaker, I just rose to really emphasize this point that I see no reason why we should be cooperating with the national bodies and we are not establishing our own court really to fully handle some of our cases. So thank you, Mr. Speaker.
Thank you very much, Honorable Alak. Honorable Wanjiku.
Thank you, Honorable Speaker, for giving me the opportunity. And I start by saying the report is very good. And I also say, I don't know if our assembly do organize to invite the stakeholders when we have such a report. For instance, the Law Society of East Africa and the court. But even if they are not around, I'm sure they get the answer. But it would be good if such stakeholders are invited. I would start with point 1, saying that judges need to be full-time to enable our region attain timely justice. This is an issue that has been raised even during audit in accounts committee. We have been discussing it, and it is obvious that if judges come here in Arusha for a few days with the numbers rising every day, and also the East African knowing this court and bringing their dispute here, the justice will never be attained. So this matter, I think, is straightforward, is more to the council. Of course, it involves finance, but I think it is worth, because if we have established such an institution like a court, then it is serving in piecemeal it beats the logic why it is established. The second issue is that the court registrar and EALA clerk from the report, to me, is more administrative. And I think the council can give the blessings to the secretariat, and this is an issue that can be fixed, because if they are handling the financial matters of these two institutions, and if other heads of organs have been identified as per those classes of employee, then this is also a straightforward matter, more administrative, but I think again, council can look at it. And some of these issues can be dealt with and be left like history so that the community can move forward. The issue of autonomy of both EALA and the court. This is again council, but I think this time the council needs to come clear if they have any intention of giving these two institutions and even many other institutions autonomy. In the committee of GP, when we were oversighting the ISOA, we also have a similar issue where we are also deliberating and finding the need of institutions being given autonomy. An institution like a court, an institution like an assembly, which is still not autonomous, it's also delaying the agenda that are set to move this community as fast as expected. The second last is the one that is outlined, that the treaty do require a case to be filed within 2 months. Really? I think this is too short, and this, I don't know what was the intention. Maybe the drafters of this treaty may have the ideas what could have been the intention. But if you are given a period of 8 weeks to file a case, that is straightforward justice being denied. I could be working here. I feel that my rights are not as I expect. After 10 years, I feel that I should come back and file a case. No one should deny me this. We have seen in our traditions, like the Lad cases. Some Lad cases in our courts are back from the colonial time, 1960, 70, and our courts back at home do not limit the citizens. So this being a regional court, it is very awkward that it can limit the citizens with a technical issue of time frame, that you must file your case within 8 weeks. In fact, it is not realistic, even in terms of finance, because even filing a case, you need money, you need to plan, maybe you need to get a lawyer. So to me, that the drafters of this treaty may have been informed maybe when this community had 3 partner states, but we are growing and time is changing. And I think that is straightforward, outdated treaty article that should be looked. And again, the council can also give blessings. Some of the articles in our treaty do not really need the overhaul of the treaty. Some of the amendments can be done as we progress. I also have an issue, Honorable Speaker, with this private issue, that a private member who is not a resident of East Africa cannot file a case. Again, this is weird. I could be a citizen of Kenya or this region. I get married abroad for my own choice. I choose to add my citizenship, but my parents and everything and the culture, I belong here. So why would I be denied the opportunity to acquire justice through a regional court by the mere fact that I'm no longer a resident? I think that is also an article that should be amended without so much struggle. Finally, and the reason why I had mentioned earlier that the stakeholders need to be coming to the assembly, I also have an issue with the East African Law Society. I think in as much as we see in this report, they are doing very well. They can also add themselves a role of advocating to this community on the bills that are passed, but they are never assented to. We have so many bills, they are passed, they are never assented to. The assembly can say this, the council can say this, but as a body, which is purely dealing also with legal matters, they can help the community by advocating for such bills so that the countries that are delaying in assenting the bills can come to assent to such bills and the citizens can get the benefit. For example, the FGM bill, we are informed the third EALA did pass this bill in 2016. This bill is there, it has never been assented to. There is no report why it is not assented to. So these are lines that the Law Society of East Africa could also help the community with. Thank you very much. Otherwise, this report is good and very informative. And I hope the council will look at it line by line so that the simple things can be implemented. The difficult ones can also be deliberated. Thank you, Honorable Speaker.
Thank you also, Honorable Wanjiku. Honorable Kennedy Kalonzo, Honorable Francoise, Honorable Kim Guy, Honorable Tazana, Honorable Buru, Honorable Rosiako, Honorable Oda Gasinziko.
Thank you, Right Honorable Speaker, for giving me the opportunity. I'll be very brief. I think some of the key issues have been mentioned by my colleagues. I just want to emphasize 2 points. The first one is justice delayed is justice denied. I really want to urge council to consider making the judges of the courts to be resident in Arusha. I think it will go a long way to clear the backlog of cases. The second point I have is to emphasize the importance of harmonization of this critical sector for 2 reasons. The first one, I feel failure to harmonize is very expensive to business people. It means we are not, in fact, doing what the treaty mandates us to do, which is to encourage the private sector so that all East Africans can be employed. I mean, for example, if one is a multinational and they want to invest in any or all of the partner states, it would mean they would have to get perhaps legal counsel from all of those partner states, which becomes a very expensive endeavor and a hindrance for business. My second point is just really to remind this house, I believe a year ago, there was an issue about South Sudanese students who could not attend the Kenya School of Law, a position which has long since been corrected, but we have only done half the work. So for example, these students who are now nationals of different partner states, it would mean that if they want to go back and practice, they may have to do the bar exams again in their partner states, which I find to be a bit unreasonable. And I would really urge the council to see how they can harmonize this law to encourage cross-border trade on this important sector. I submit, Right Honorable.
Thank you, Honorable Kalonzo. Kennedy. Honorable Francois.
Thank you very much for the floor, Mr. Speaker. I declare that I'm a member of this committee, Legal Rules and Privileges, and I took part to the development of the report. Mr. Speaker, I rise to emphasize on the support this August House is recommended by the committee to support the East African Law Society and the lawyers. This is found on page 13 of this report. And I focus on Roman 6 of this support we are requesting. Urge the Council of Ministers to extend the jurisdiction of the EAC to include the human rights and the other matters and appoint judges of EACJ. What is important here for me is human rights. Mr. Speaker, by urging the council doing so, we know that the concept of human rights allows people to speak up when they experience abuse and corruption, among others. It also empowers people and tells them that they deserve dignity. They deserve dignity from society. In our case, Mr. Speaker, from EAC as a community, EAC is dignifying through EALA as an assembly
EAC citizens in advance. Allow me also to focus on human rights and why we have really to stick on this as we support EACJ and also Law Society of EAC. In 1948, the United Nations released the Universal Declaration of Human Rights, which has become the most important document of what should be considered the standard for basic equality and human dignity. Human rights matter because, first of all, they ensure people have basic needs met. It's very important. And also they protect vulnerable groups from abuse. They allow people to stand up to societal corruption. They encourage freedom of speech and expression. They give people the freedom to practice their religion or not practice any. Mr. Speaker, the reasons why human rights matter are many, but allow me to add just 5 more as follow. Human rights allow people to love who they choose. Of course, I add that the law regulating the practice should also be put in place. They encourage equal work opportunity. They give access to education. Mr. Speaker, we all know, we can recall how education is the paramount in this community because illiterate rate is still observed in EAC. And with people are not well educated, we will still have corruption issues because if you can't read, you can't even follow what is happening as far as corruption is concerned. Human rights protect the environment. We all recall how this assembly is passionate with environmental protection through tree planting, for instance, and also mitigation of climate change, which has a negative impact on the livelihoods of EAC citizens. This is why we have also to make sure human rights are protected under EACJ. Lastly, human rights provides a universal standard that hold the government accountable. Hence, supporting the activities of East African Law Society and also supporting EACJ is supporting the principle of people-centered in this community as it is highlighted by the treaty and the principles and first objectives of the treaty. Mr. Speaker, I beg to submit.
Thank you very much, Honorable Francois. Honorable Kim Guy.
Thank you, Honorable Speaker. Honorable Speaker, I'm going to be very brief. But before I move to my point, first of all, let me congratulate the Republic of Kenya. And seeing our share is here, share of the council. Let me congratulate them because they take over the UN Security Council for sharing the UN Security Council. Congratulating our brother. Honorable Speaker, and also let me congratulate my share. I'm a member of the Committee of the Legal. Well done. I'm not going to be I'm going to be very brief. In Article 63 and Article 22 of treaty. Honorable Speaker, in Article 62 of treaty, which is a son of the bill. I think this issue, Honorable Speaker, is a very big issue. Let me read Article 63 in page 45. The assent to bills. A bill that has not received in two, that means one, the head of the state may assent to or withhold assent to the bill of the assembly. Number two, a bill that has not received assent as provided for in paragraph 1 of this article within 3 months from the date on which it was passed by the assembly shall be referred back to the assembly, giving reasons and ways a request that the bill or a particular provision therefore be considered by the Assembly. The point is this, Honorable Speaker. I think now we are talking about the bill that have been assembled in 2016, 2014, blah, 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 blah. I think, Honorable Chair of Council, this is part of the treaty. And treaty requires only 3 months. If the bill has been returned to the office and you do not send it, you have to return it back. Or from the beginning, for us here, we are reconciled in Parliament. If you have any issue on those bill, on the report, please don't accept it here. I will not pass the bill. So we have to move forward. Why we want to record ourselves every time for those things? And this one is not a treaty. And last one, Mr. Speaker, it is also Article 23 in the treaty, which is in page 26. Also, because it's part of the report of the committee, the issue of the judge. Because the report here in page 15 says, development and adopt the regulation guideline on appointment of the judge. Right, Speaker. And I see now, the chair of council also, you have to develop, because I see now South Sudan in the first instant division, they are not there because the treaty are not amended, and even South Sudan cannot be there because those this division it is only for 5 partner states. DRC is coming, South Sudan are there. I think this thing it is a matter which is very important, and South Sudan should be appointed there. So I think in next summit, I think you have to do something, Honorable Chair of the Council. So with this, your Honorable Speaker, I beg to see you.
Thank you. Honorable Kim, I'm not sure the council chair will be able to get to the last point you made because I also have problem understanding it. Maybe I give you a few more minutes to elaborate on that. The last point you raised, to be sure that it is properly understood.
Honorable Speaker, what I'm saying in the first division of the court,
the instance, the division.
Yeah, of the court. Yes. South Sudan they cannot appoint any judge in that until they amend the treaty. Yeah.
CTC yes. Understands your point. So, very good. So at the right time, we have to respond. Honorable Rutazan.
Thank you, Right Honorable Speaker, for the opportunity. I would like to commend the chair of the Legal and the Privileges Committee for a good report. And I declare that I'm a member of this committee. Right Honorable Speaker, I have some comments. Look on the observations and the recommendations. This report is in the most part receiving the complaints from the court than the best practices we have been waiting from them, because they have many issues that should be received by the relevant authority, such as the Council of Ministers and the CTC, to help them improving their work. But in vain, it is in the other side. They are complaining for most of the things they are doing because they are stuck somewhere. Right, Honorable Speaker, when we can imagine a case on page 8, whereby, for example, we have a beneficiary of the judgment coming back to sue again because he has not received the judgment. That is really an issue to be taken seriously, because if there is no access to justice for that person, that is a justice denied. Right, Honorable Speaker, we have universal court, which is saying that justice delayed is justice denied. But in this case, it is not delayed, it is denied. So we need really to look on that and help those people of the East African community to access really the justice. it serves. Right, Honorable Speaker, it is like giving on one hand and take that thing in another hand, which is really not acceptable when it comes to give and provide the justice. Right, Honorable Speaker, when we see in this report, since 2015, more than 16 years, the council approved and granted the financial and the administrative autonomy to the court. And the roadmap has been given by the court. But until now, there is no implementation. We urge really the council, we need their response and the feedback on that, because that is really another harmful of the court to be able to implement effectively and to provide the justice, which is really needed in this community. We need the council to look on those recommendations we have in this report. They are clear, they are implementable, and we need them to take them as a serious matter so that we can help our people in this community to access really to justice, because that is one of the things which is relating to the human rights and relating to the dignity and respect of this community if we need really this community to move forward. I thank you very much.
Thank you to Honorable Rustazan. Was the next Dr. Bull? Yes, okay. The microphone.
Thank you, Mr. Speaker, for the opportunity. Mr. Speaker, I think most members who have been commenting are members of the committee, but I'm not a member. I must confess I'm not a member of the committee. And I just want to make a few comments. First, I want to commend the committee for a very good informative report. Some of the things they have highlighted here are actually very, very informative because, for instance, on the issue of autonomy, which we have been discussing in various forums here, I did not know that actually this matter, since it was recommended by the council in 2015, that there was a roadmap report which had already been drawn by the registrar and the clerk of the assembly and given to the council for implementation. I mean, because it was on the request, actually it was based on the resolution of the council. So the council was given a roadmap to implement. The council, from the report we have here, pushed it to the CTC for comment. And the CTC also gave a detailed feedback to the council. And the council again requested for further clarification from the CTC, and that the CTC is still sitting on it. Up to today, they have not given the council back. So I wanted to blame the council for not taking action, but council has already taken action. So when a CTC, please pull up your socks and give the council the clarifications they needed from you on this matter of autonomy of the courts and the EALA, because this is one of the cardinal principles of democracy, that is the independence of the institutions. The courts are supposed to be independent in a democratic society so that they can make decisions without interference from the executive. And the same with the EALA, they are supposed to do the oversight, and you cannot do the oversight of an institution on which you are fully dependent for decisions and for guidance and for even
making your own programs. So, Mr. Speaker, I think this is one very important area which has been exposed, and at least it has made us aware that something somewhere has been moving on, but of course, eventually it will need the amendment to the treaty, which will then give the full autonomy, which is not given yet in the treaty. But there are provisions which can, there are some areas which can be implemented without amending the treaty. And those are the areas which had already been recommended. And I hope the council will expedite this process so that at least some level of autonomy can be given to these two institutions, EALA and the ECJ. Mr. Speaker, I also note the area of ad hoc nature of the judges. This does not give the judges the confidence and the opportunity to be resident here and make thorough judgments, because most judges, as has been exposed here, are both judges in their own countries and also judges here. So that does not give them the time and the confidence and the opportunity to look at the cases which they are looking at thoroughly, and also it does not give them the time to expedite cases, because as Honorable Francine was saying, justice delayed is justice denied. So this ad hoc nature of the judgment should also be considered by the council and recommended to the summit, and if need be, the treaty amended to give that provision for the permanency of the judges in Arusha. The other thing which I also noted, Mr. Speaker, is the implementation of the judgments. The implementation of the judgments has been left to the partner states, and just like all the other provisions in the treaty here, and also in the community, that judgment and implementation of even protocols and judgments here in the EACJ are left to the partner states. This is a provision which makes it very difficult for the courts to ensure that these judgments, the judgments they make here, are implemented. Therefore, the council should make provisions, or if not possible, recommend for amendment to the treaty, so that the judgments made by the EACJ are superior, and as they should be to the judgment, to any judgments in the courts of the member states, and that these judgments should be compulsory. I mean, they should be mandatory for implementation in the member states. And even though they will be implementing, but it should be mandatory. It should not be left to be their own affair, whether they implement it or not. And now there is still this delay in assenting to bills, Mr. Speaker. It's also something which needs to be taken seriously. I saw Kim Guy raising the issue here of what should be done, that if a bill is sent for assent and it takes 3 months before it is assented to, the council should be reporting back to the assembly on the reason and giving reasons as to why such bills are not assented to. And Mr. Speaker, so many bills are pending, and I have never heard since I came to this assembly any report from the council giving reasons as to why those bills have not been assented. If it is now the policy of the council and the community that private members' bills should not be tabled in this house, then let the council bring all the bills. Let them bring the bills and take over any private members' bills so that at least members' bills can be taken into consideration by the summit, because these delays are very harmful to the community, because members are supposed to contribute and also bring bills before the House, and this process of taking too long without any feedback to the Assembly is actually demeaning the Assembly and making the work of the Assembly completely handicapped or useless. Mr. Speaker, with those few remarks, I beg to support the report. Thank you, Mr. Speaker.
Thank you, Dr. Oburu. Let me exhaust the list I did. Then I come back to those members whom I hadn't mentioned before. I think we have time for everyone. Honorable Rose, but let me make an exception to Honorable Rose. Let me make an exception to this informal rule. I had two members remaining, the Honorable Rose and the Honorable Oda. Then, of course, I would pick a new list. But we have always given a priority to a member who wants to make his maiden speech. So I have seen Honorable Kakoza trying to catch my eye. I also recognize the presence of Ambassador Baruch, member of the council. So Honorable Kakoza, you can proceed. Then Honorable Rose will come after. I think she's in agreement with that. All right. The microphone isn't working. You can use the next one. The another microphone next to where you are sitting. Can you try the other one? Yes, please.
First of all, I want to thank you, Right Honorable Speaker, to give me this opportunity also to add my voice to this debate. My name is Kakoza James, representing Uganda. I want to thank the committee that it has given the insight and highlight of a comprehensive report, which I think most of the members have commented on. But I would like also to give some comments and observation of what the members have been talking about and what I think that this House should emphasize more and have a priority to carry out our legislative role. Because, Right Honorable Speaker, when you look at the recommendation which is given by the committee, that is 8.07. If I read it verbatim. Finally, the process of granting the East African Court of Justice and EALA the financial and administrative autonomy of matters that does not require amendment of treaty while awaiting the amendment of the treaty. Right Honorable Speaker, this is quite important for the functionality of any assembly in the partner states. It must have a marshal. It must have support, finance support, and you must carry out your oversight function when you are independent. Because if you are not independent yourself, then you cannot carry out an oversight function to monitor or to audit what your master is doing. So this one, it must be a priority as an assembly, that really, if it needs be, if there is a bill which needs to be brought by what we call Administration Act of the Assembly, it highlights and empowers the Assembly to audit what the councils are doing. This way you accrue the Treasury memoranda. It cannot be really, it doesn't augur well. Parliament sits here, we come here, we make laws, and they are not assented. What does that mean? It means they are rendering the Assembly doing no work, or to think that we are wasting a lot of time to come here. We are the representatives, we are the summary of the partner states. These partner states, they agreed with the treaty, and the objectives are clear. If you really want to integrate, it's like somebody who has married, you've agreed to produce children, but when you go to bed, you don't want to open up your closet for these children. Look at the movement of people. I've heard somebody mentioning about lawyers in partner states not moving. This is a non-tariff barrier. How do you expect movement of people to work out, to move in partner states when they are not free? Then you are not ready for integration. I think these are serious points that really where it needs to be. If we have a private members bill and the feedback of the Council of Ministers to make them work out, we should introduce a bill which is called the Treasury Memoranda, where Parliament comes and sits here. We have to get the feedback from the councils, and the resolutions have been made by this House. We have to force them to do it, because otherwise, if we come here, we pass resolutions, they become advisory, it means we are wasting a lot of time here. That's my comment on that. Then, Right Honorable Speaker, if bills have stayed in the office, one office for 3 months, let's have a law where we feel that once 3 months Parliament has passed laws are not assented, it becomes a law. We've got to live from other constitutions, because if a bill is not assented to and they are not returned, it means you've accepted or not. In other countries, in partner states, Right Honorable Speaker, I've been in the European Union. I'm a member of the International Trade Council. They have a rule that whatever is passed within their parliament, their assembly, if it's not dealt with within a certain framework of period, it becomes a law. Let's borrow it within the East African community. If the Council of Ministers are not moving, then we should move. We cannot stay in the same position as we started. Now in the customs union, common market, you can look at, we are still thinking of these non-tariff barriers. How do you expect to integrate when you are still having non-tariff barriers, where there are no movement of people free? I think this assembly, Right Honorable Speaker, we should get where we think the priority have to be, which can make us and move and integrate very fast. Thank you, Right Honorable Speaker.
Thank you, Honorable Kakoza. If you can switch off your microphone. Yes, so I think you, Honorable Kakoza, has hit the ground running. And the message is very clear. Now I come back to Honorable Rose.
Thank you, Right Honorable Speaker. First of all, I want to take this opportunity to welcome our new legislator, Honorable Kakoza, to this house. It's the first time we are sitting together here physically. So you are most welcome. And as you may note, members have been waiting for this opportunity to be with you here. So you're really welcome. I also want to welcome the council member who Ambassador Mbaruku. I think I'm seeing him for the first time here. So you're most welcome.
Yes, thank you. The Right Honorable Speaker, I'm a member of this committee, and I want to commend the team that has prepared this report, including me, for this very precise report, and which I want to request the council members and the special chair council to pick all these recommendations and see what to do about it. They are very, very important and timely. On the issue that has just been delved in by Honorable Kakoza on the issue of autonomy of these institutions, I think we have all gone through some management administration training, and these are principles of good governance that we at the region should also adopt, where we exercise the given principles that the three arms of government should be independent, and that is to be autonomous in the way they perform their duties, because we all realize that it is what we practice at home. Why not at the region? If we uphold this principles of good governance at home, why not here? So I think the council chair needs to tell us really what's going on, because it is long since this approval was made by the council, and yet it is not being implemented. So we will be waiting to hear from the chair council. And on the issue of the upgrade of the three key staff, and that is the clerk, registrar, and the CTC. This one has also been, I think, talked of for quite a long time. And it goes also to reflect what is happening with the review that had just been concluded. There are many, even when you look at the staff levels, you will find even within staff that they are doing the same, they are the same level of responsibility, but different grades. You'll find a G3 performing the same duties with a G4, and then when this G3 tries to ask to be upgraded, they are not upgraded, and they are frustrated, Right Honorable Speaker. So I think this is a serious matter that needs to be looked at. It encompasses the issue of motivation of our staff. We need to motivate our staff by the way we do things here, because this upgrade was prayed for, I think, since I came here. This is what's happening. Just like when we talk about staff salaries, since 2006, no salary increment. And so many things have changed. The standards of living have changed. The prices have gone up. The price of sugar in 2006 is not the price of sugar today. How do we motivate our staff to work and be effective in what they do if we cannot look into these staff matters that are very, very striking, Right Honorable Speaker? We need to do something about it. I believe now that we have Chair Council, he has taken note and he'll give us a good reply to that. Right Honorable Speaker, the review of the treaty is another matter. This treaty has many provisions that have been overtaken by events and that are also holding us from moving and fast-tracking the integration process, Right Honorable Speaker. I believe by now, the Council of Ministers should have set up a committee to review and receive input from various stakeholders on the amendment of this treaty. It has been in use, and we now know the shortfalls in the treaty. Just like, I want to give an example. In accordance with the current legislation, our speaker is not supposed to fall sick. He's supposed to be there every day because they have not provided for him a deputy. I know because of that, the rules were so, and we decided to make sure that perhaps when something happens to him, a member among ourselves will sit on that chair, but we need to have this looked into. We need a deputy, just like we have in our member states home, in our member states at home. We need a deputy, and that would also be an opportunity to train someone who would take over after him. I mean, it is rotational. So the country that is believed to be the next in line would be the deputy, would provide a deputy speaker. It would be very right, I believe, Chair Council, on this one. So this treaty is long overdue for review and amendment on quite a number of issues, and the time is now for it to be done. Right Honorable Speaker, the issue of harmonization of laws, non-harmonization of laws by EAC partner states, as a challenge that we identified as a committee. I think it's a high time we give timeframes to some of these issues. Just like Honorable Kakoza said here, that once we have passed a bill and for some reason it is not brought back to Parliament for amendment, and it stays over a period of 90 days with our heads of state. After 90 days, then we can assume that it has been consented to, because silence is consent. So the same should apply to harmonization of laws, where it will be deemed.
Silence is consent in some situations.
Maybe in this one as well, Right Honorable.
In some others,
assume.
if you presume consent, it can be criminal.
Right Honorable. Yes. So even on non-harmonization of laws by EAC partner states, I would want to request as one of the activities, Right Honorable, that we need to schedule for this committee, to come up with a schedule of all the legal frameworks that are yet to be harmonized by all our partner states. And then we see what to do as an assembly. The same applies to the legal frameworks or the bills that were passed here and are yet to be assented. We need to maybe come up with a schedule, then review them, and maybe officially write and request for reasons as to why there is a lack of harmonization on the laws that have been passed, and also the reasons for lack of assent, so that we have a checklist of these frameworks that have not been harmonized, and also a checklist of the bills that have not been assented to yet, Right Honorable Speaker. So basically, Right Honorable Speaker, that's all I want to say. And I really want to thank again this committee for the work well done. Thank you, Right Honorable Speaker.
Thank you very much, Honorable Rose. Honorable Gasinzibo, order.
Thank you so much, Right Honorable Speaker, for the opportunity. Let me also take this opportunity by inviting our new colleagues, Honorable Council Member, and our colleague, my brother, Honorable Kakoza. You're welcome. We are happy to be with you in this important engagement in the Assembly. Right Honorable Speaker, I'll be brief. I'm not a member of this committee, but I want to take this opportunity to thank the chair of this committee for the well done report, and the members of this committee for this very, very important activity they undertook, especially in the matter related to our community, especially on the laws and legal rules, all the regulations concerning our community. Right Honorable Speaker, mine is mainly on the methodology, In the report, it is clearly stated the institutions or the department consulted. But on my view, and in the report, it is clearly stated that our very, very important sectoral the sectoral council on judicial was not consulted, and it was not the fault of the committee. It has been stated in this report that CTC informed the committee that the judicial sectoral council is going to meet and report back to the committee, if I'm not mistaken. And I think for me, this is the sectoral council on judicial is very important for updating the council, but of course, later on informing through our committee on the progress on all these issues which have been discussed. So I see, Right Honorable Speaker, a gap here in this report because the feedback was not provided, and we are discussing on the matters supposed to be followed by this important sectoral council. And Right Honorable Speaker, if I remember well, in different reports, we have been informed. Maybe I'll get an opportunity to be informed by the chair council if this sectoral council meets. This has been a challenge for quite some time now, and we depend very much on this sectoral council. So I feel that this mandate, this exercise was huge, looking into assessing the development of the legal sector in the community. This is a very, very huge mandate. And I feel that consulting only the court and discussing on the mandate of the court, that was very good. Consulting the legal, the law society, that also was perfect. But when I go to the part of the CTC, when this committee consulted the CTC, I'm sorry to say that I was disappointed. I'm disappointed because I was expecting that at least when they were consulting the CTC was in a position to at least give the update, because I assume that the CTC sits also in this or follows closely this judicial sectoral council. And that would inform the committee so that when this committee brings this report in the assembly, then it covers this important element on development of the legal sector in the community. For me, this is a very, very big component of this development, implementation of our treaty. So maybe the chair of the committee will inform me on how they intend to take forward this, because I feel even if the council chair is going to give us the feedback on some questions here, but I don't think he's going to be able to give us the whole the updated version vis-a-vis what the council, the sectoral council have updated on this report, so that even the council chair can help us to continue following it up. So that was my main point on this report. And I feel that if the assembly allows, and if the budget allows, it can give another opportunity to this committee to go and dig deep on this matter, and also consult the partner state on these issues related on where we are as the community on the legal matters. My sister, Honorable Rose, mentioned on the harmonization of our laws in a partner state. There is also another component on how do we relate with our partner states, especially the parliaments, our national parliaments. So it has a it is very diverse. There is civil society, there is the private sector, we see the national parliament, we see our different sectoral councils. In all those sectors, I feel that there are legal components and harmonization of laws if we are really following up on the integration of EAC. So that's my concern, and maybe I will get some clarification on it. On issues mentioned by my colleagues, the issue of autonomy, Right Honorable Speaker, for EALA, for the court, this has been, discussed since we joined this assembly. And I feel that our council, and especially our council chair, our able council chair, please, during your time, I feel that you can help us on this. Either we say it is possible or it is not possible, and we close the debate on this. I feel that our able chair, council chair, can really help us and come back on this matter, and we discuss about it once and for all, because it has been discussed, all the documents are in place, so I feel that we need to finalize this once and for all. Right Honorable Speaker, on the issue of assent on the bills, there was a time I felt I would bring the motion in this house on this, but at the same time, you find it's something which you have been again discussing. So wanted again to hear from the council chair, when are we going to get the updates and the way forward on this? We need also to finalize on this and understand what we as assembly we're supposed to do on this matter. It is frustrating, Right Honorable Speaker, when you want to come up with a bill, it's not an excuse, but again, it's a matter of fact that when you look into, you have an idea and you look on the list, you find most of the, and I want to appreciate our colleagues in previous EALA members, they have come with fantastic proposals on these bills, but we don't know where these bills are. So we talk about the resources of the community. So do you bring another bill on the same nature? Why you don't know even the update on the one which has taken a lot of resources of this community? So this is another area where we need to really work hard. And if we are going to be happy before the end of this EALA 4 mandate, if we can at least leave a good legacy to the following EALA, so that they can know where to start from, at least on what has been done by previous assemblies. And lastly is on the treaty. This has been also another song of the day. The treaty has been there, discussed, left and right, but we don't know the amendment of the treaty. What is the challenge? We know the resources of the community are scarce, but we should see at least a step forward. What are the stages? What is the framework? Where are we? Have we done the first phase? We failed the second phase because of the resources. Have we reached the third phase? So we are failing on some technical capacities. So what is it? Because there is no progress report, there is no update on where the challenges are. It is only it's a big, it's a problem there. When you want to touch it, it's resources, resources, resources. So where are we starting? The resources starts from where, ends where. So I wanted also to request our council chair that we have a framework on these pending issues. Even if we cannot be able to finalize it in 1 or 2 or 3 years, but at least we know a step. It has started from one stage, it is on the third stage, or it is still on the 0 stage. And that is where the challenges are. What are the responsibilities of all organs of this institution? What are the responsibilities of EALA, of the council, of the member states, of the summit on these issues, so that we can know where we are going. We can have something to send back or to give back to the citizens of this community who have sent us here. So sometimes when we go back home and sensitize on these issues, we fail to respond on some questions because we don't have by ourselves, we don't have response on some of these matters. What are you going to tell the partner state?
when you are back home, the citizens in your partner states, why you don't have the update information on these issues we are asking every day. I want to rest my case, Right Honorable Speaker, and thank you so much, and want to thank the committee. And I want to once again to request that if resources allows, this committee be given another opportunity to go and come up, dig down and come up with more issues so that can be debated in this assembly. I submit.
Thank you very much. If you may switch off the microphone. So the next list, Honorable Fancy, Honorable Susan, Honorable Dr. Ann Ito, Honorable Pamela. But before, let me Fancy, Susan, Dr. Ann, Pamela, but there is at least one person who needs a health break of 5 minutes. So I will suspend for 5 minutes.
Resumption of business.
Thank you. Honorable members, I think before we resume the debate, I wanted to apologize. We made a mistake. I made a mistake when we were starting the plenary today. We recognized those who passed on, and we observed a minute of silence in their honor. But I didn't mention it in a special way, the passing of the former council member, Honorable Olenasha. You remember him very well. At the time we served with him, although it was not long, but he left a memorable mark. So he passed on, and I was fortunate, together with Honorable Makame, Honorable Magembe, Honorable Giko, to be there for his burial in Ngorongoro. So may I request you again to rise for a minute to pray for his soul. May his soul rest in eternal peace. Thank you very much, and the apologies for that omission in the beginning. So now we resume the debate. I think the next member to take the floor is Honorable Fancy.
Thank you, Right Honorable Speaker, also for giving me a chance to add my voice in this report. On the onset, I support this report 100%. And I'll be very brief because most of the issues has been raised by my colleague who spoke before me. And I'm here to just put emphasis on some of the issues raised. Right Honorable Speaker, I believe in order to be realistic and help this community move forward in a good pace, Council of Ministers need to let the EALA and the court to be autonomous. When we joined EALA, the first debate was to operationalize the autonomy given by the summit to EALA and the court. But until today, I think we're almost the fourth year, that has not been done. Another thing is, I would like to know from the Council of Ministers, until when will East African Court of Justice will serve as an ad hoc basis? They've been operational for 20 years now. And I don't understand how much time that the council need for them to be fully operational and not working as in an ad hoc basis. Right Honorable Speaker, I know in our partner states that judges have the security of tenure, but when I was reading this report, I found out that this is not the case for the judges in East African Court of Justice. So how do we expect them to work without fear or favor when they're discharging their duties? And again, how can we claim to have a court which decision cannot be implemented by the partner state? It's like we have a toothless bulldog that can only bark but do not bite. So it is very important, all the recommendations and all the issues raised in this report to be implemented. Right Honorable Speaker, on behalf of the lawyers in East Africa, I must declare interest that I'm also a lawyer among the lawyers in East Africa. We are eagerly waiting for the law on East African cross-border legal practice. We are doing that informally. We need to do it formally. So Council of Ministers, on behalf of the lawyers in East Africa, please do make this happen.
Right Honorable Speaker, I thank you.
I thank you very much, Honorable Fancy. Honorable Susan.
Thank you, Right Honorable Speaker. And I want to also add my voice in appreciating the Committee on Legal Affairs for this report. Also add my voice on a few issues that have been raised in this report, starting with the issue of jurisdiction of the court. I'd like to put it to Chair Council, just in case you're not aware, much as the treaty does not expressly grant extra jurisdiction to handle human rights cases, actually this court has been delivering justice to East Africans on issues regarding human rights. Usually when I draw your attention to the treaty, Article 7, Article 6D and 7.2, actually under 6, where we talk of fundamental principles of the community, in the fundamental principles of the community, they talk about respect of human rights. And then under Article 7, in 7, we talk about the operational principles of the community. And in the operational principles also, we talk about human rights. I know the issue of the human rights jurisdiction was deferred at that time when they were enacting the treaty. But I think that time is ripe for council to take action and expand the jurisdiction of court. I'll give you examples. I remember in 2013, there's a case of Burundi Journalists Union versus the Attorney General of Burundi. The journalists filed a reference before the East African Court of Justice, challenging the press law in Burundi. And in that reference, the courts, actually, the first question they had to deal with was whether they had jurisdiction to hear such a matter on human rights. So the court borrowed the provisions of Article 6D and Article 7.2 of the treaty and actually had this matter. And this matter, because it was won by the journalists of Burundi, they succeeded in that reference. It attracted more litigation on matters of human rights. Actually, there's also another reference by the journalists of Tanzania about the press law in Tanzania, and they also succeeded. There's also a matter from Uganda, the famous Katabazi case. Actually, this involved people who had been released on bail by court, and then they were rearrested. Still, Katabazi came to the EACJ on the issue of violation of human rights, and courts used those very two provisions to administer justice. So what I'm trying to show Chair Council, this is not new. Council just needs to do what they have to do, just expand the jurisdiction so that we don't waste a lot of time in court deciding jurisdiction. And I know all international courts evolve over time, following the social, political dynamics. Why can't we do the same? Why should we be stagnant? I know the judges have been crying for this, so I would implore council to give them this probably as a present. Secondly, on the issue of the 2-month rule, for those ones who have to apply before the Court of Justice. I know the process of treaty amendment has been ongoing for quite a while. Actually, I don't know why it's taking council this long. I don't know if council is just not up to the task. How do you really consider amendments for more than 5 years? Where is the problem? As the Assembly, we are here to help you. If you're not up to the task, please give us the job. We shall do it within the shortest time possible. Because there is a lot of justice that has been denied just because of these requirements of 2 months. It requires that a reference be filed within 2 months since the start of the alleged violation, not even the end, because there are those continuous violations of human rights that exist, or there are those offenses that are continuous in nature. They don't even look at the tail end, but just the start. So I would implore council to look into this. I know there's this case where it was Attorney General of Uganda and another versus a warder. They came before the court, the EACJ. They really wanted justice. But the court was hesitant to even hear the matter, saying they cannot compromise on the 2-month rule, which I found unfair because the recourse for those who are helpless is the court. So if the court is going to use technicality and deny justice to the people of East Africa, it's not called for. So we seek your intervention as Council of Ministers. Thirdly, I also want to talk about implementation of justice, of decisions of the court, as clearly stated in the report of the committee. We are very much aware EAC has been taken to court several times. A case in point, we've had the case of Right Honorable Margaret Nantongo Zua versus the Attorney General. She was awarded a remedy by the EACJ. And more than 2 years down the road.
I think you meant Veza's Secretary General.
Yes, versus Secretary General. Yeah. More than 2 years down the road, we've not been able to pay as per the court directive. So as EAC, if we are not able to respect the decisions of our very own court, what will others do? What will the partner states do? I think we're supposed to lead by example. I remember the costs which were awarded to Honorable Margaret Zua, they even accrue interest. That was a directive of the court. They accrue interest per year, per annum, at the bank rate. So we are going to end up paying very high costs because we've been adamant to follow the directive of court. In fact, Council, when you read Article 38.3, the treaty is very categorical. It says without delay. I would just read it verbatim. It says a partner state or the council shall take without delay the measures required to implement a judgment of the court without delay. Now, this is too much delay as things are. So, Council, please take action knowing that we've over delayed. And also, I would also like to talk about the issue of the housing of the courts. Since 2001, when the EACJ was instituted, they have never had a permanent home. They started in renting a commercial building along this road, is it Arusha Namanga, with other tenants on the building. And then we moved them to the EAC headquarters, which I find very disturbing because the users of these courts are not comfortable with where the court is housed. EAC, we are among the litigants in that court. So many times we're pursuing the Secretary General, or it's us using the courts, and then we keep mingling. So people feel maybe they cannot get the justice that they require to have. We've been having issues recently where East Africans have run to these courts. I know Waswa Bernard and Chigozi Peter. On 10th of August, they went to this court to seek justice on issues of recruitment in the EAC. Recently, the court listed the matters they are going to hear, and their matter was not one of them, yet there's a certificate of urgency. So to them, they are thinking, maybe because the court is housed here next to the SG's office, that SG is influencing whether their matter should be heard or not. So Council, we request you to urgently find a home for the East African Court of Justice. Let them go and be their own. Let them be as independent as they can be so that our people can have confidence in this court. And finally, the issue of autonomy of the courts and the assembly. Chair Council, the very Council of Ministers sat and came up with a directive that both the courts and EALA should be autonomous. We are talking about administrative and financial autonomy. It came from council. It's a directive that is existing. But when it came to implementation, it became a problem. I don't know why it became a problem, because the way you came up with the directive is the way you should fight to see that this directive is implemented. How are you going to be sure that that court is independent when it's still under somebody? When it still has to run to council for assistance, it has to run to the Secretary General for financing. Even where they're given powers expressly by the treaty to recruit their own staff, they're not supposed to recruit. Where is the problem? So council, we seek your indulgence. We request that you take urgent action on these matters that have come up in the report of the Committee of Legal. I want to submit and I support the report.
Thank you very much, Honorable Susan. Honorable Dr. Anne Ito.
I want to thank the Right Honorable Speaker for giving me the opportunity to add my voice to the debate, and I rise to support the report. I would like to start by thanking the chair and the members of the Legal Committee for presenting to us a very excellent report. The reason why I say so is that they carefully look at the legal sector and clearly identified issues, and then they gave implementable recommendations to how best to resolve them. I would have gone through details if Honorable Susan did not speak before me, but I'll quickly highlight areas where I thought this report is very, very important. And in fact, they're highlighting the gaps that exists. Number one is the issues related to extension of the jurisdiction of the EACJ. The East African Court of Justice. I think it's easier that way. This is since 2005. And if it was a child, and the child would be in the university by this time. And this responsibility lies squarely in the hands of the council. The fact that this jurisdiction of the East African Court of Justice has not been extended to include human rights is squarely the responsibility of the council. What are you afraid of, council? Are you afraid that they'll be exposing things, or are you afraid of their ability to judge human rights cases? I don't think either of those is the problem. I think you just need to move so that, as Honorable Alak said, people don't leave East Africa and go to seek justice outside the region of East Africa. In fact, it's embarrassing. If people leave a court here which has capability and go all the way to Europe or America, whatever the case, in order to seek justice, I think it's very embarrassing to us. We need to do the right thing so that we would be seen to be taking care of our people. The second area is access to the court. Why is the court there? The court is there so that it can be easily accessed by East Africans, regardless of where they reside. Now, if people, just because somebody lives maybe in Egypt or Ethiopia and has a case here and they cannot access the Court of Justice then there is a problem. And if that requires it to be taken for, if it's an amendment that is required, I think it's very important so that our people get justice. And already issues related to administrative and financial freedom has been raised. That's a real issue. And then there is non-implementation of Article 46.2, which is also employment, the right to employ staff of the Court of Justice. The ad hoc nature of the judges has already been raised. The difficulties in implementing of the judgment has already been raised. And lack of assent to bills that we have passed here are real issues. You know, I really want to conclude by saying that we all have our responsibilities as organs of the East African community. The Council of Ministers has its responsibility, just like EALA has its responsibility in doing oversight, passing bills, passing budgets. As I see it, this report is pointing fingers at one organ of the community, and it is the Council of Ministers. And we know that you're capable of doing it, but I think you may need a bit of pushing from people to say, look, there are these gaps that needs to be addressed. And in fact, today we are saying these gaps need to be addressed because they're very, very important. If they remain, it means the implementation of the treaty will be difficult because institutions will not be effective, but also there are some people who will not be able to access justice because of the gaps that exist in the legal sector. Honorable Speaker, I would like to stop here. My emphasis is for the Council of Ministers to move and implement these important recommendations offered by the Legal Committee in this very important report. Thank you very much.
Thank you to Honorable Dr. Anne and honorable members. I think we have given good justice to this item. So I had mentioned the Honorable Pamela. She will take the floor, then we come to council to wind up this. And I think you agree with me. Yeah, thank you. So Honorable Pamela.
Thank you, Mr. Speaker, for giving me also the opportunity to add my voice to this report. First and foremost, I would like also to join my colleagues to welcome our official member, Ambassador Mbaruku, as well as my brother, James Kakoza, Honorable. You are warmly welcome. The second point is, Mr. Speaker, I want also to congratulate the chairperson, Legal Rules and Privilege Committee, members of the committee, and as well as technical personnel for this eloquent report. Mr. Speaker, I have just only 2 points to make on this report. And one of these points, we've seen the issue of having the pending bills. The pending bills in this community, we can say there are a lot of them. But I think it's high time now for the Council of Ministers to buy the proposal, which was posed by my sister, Honorable Rosa Ko, of either accepting and putting the proposal of amending the treaty, or otherwise they should come up with another strategy on how they're going to push on the assent of these pending bills. Because we've been seeing a lot of bills coming and we're expecting more to come, but I don't see the practicability of these bills to be assented at this by this period of time. So we need to hear from our Council of Ministers. The other point, Mr. Speaker, is just a general observation and recommendation that this House has been posing a recommendation and arguing the Council that we need to receive a report on the status of implementation of the protocols, as well as the recommendations which have been put by this Assembly. If we don't receive the status of implementation or the report of status of implementation, I think this house will not be doing justice to the community, because you can see every report has the recommendations, but the Council of Ministers have never put a commitment as on how they are going to implement the recommendations. And we don't know the recommendations which we have been putting, how far are they? So, Mr. Speaker, I plead with these members of council to take this and to promise this house that when now we are going to receive the report indicating the status of implementation of the reports which we have been doing and the recommendation which we have been posing to this house. Mr. Speaker, I beg to submit.
Thank you very much. Now, may I ask the council, and by council, I mean any of you. It is council chair, but he knows that he can always invite any council. So, Honorable Chair, Council.
Thank you very much, Honorable Speaker. I want to start by thanking the Committee on Legal Rules and Privileges for producing the report, which we have extensively discussed and views highlighted by different members. Honorable Speaker, I also want to start by apologizing for coming in a bit late. I had thought that this session was going to be in the afternoon, but started earlier than that. I want to make my submissions in two broad areas. One is to respond to some of the issues that were highlighted by honorable members in relation to this report, but also talk generally about some of the broader EAC issues, especially those that are touching around the treaty that underpins everything that we do or don't do. I think on the specifics of issues around the mutual recognition, for example, of lawyers within the region, this is something that the Sectoral Council on Legal and Judicial Affairs is considering, and we hope that they will be able to fast track that discussion. The issue of the common market, which was also highlighted and raised by honorable members, the implementation of the common market, as I'm sure all members would appreciate, is progressive, and we have monitoring committees both at the regional as well as the national level. And that exercise will continue to make sure that common market dream becomes a reality. The issue around the extended jurisdiction of the court, which has been highlighted by a significant number of members, is, Honorable Speaker, I just want to highlight the commitment of partner states to ratifying the protocol on extended jurisdiction of the court. And the council will, as part of the recommendations that were given, consider the issues around the human rights, be included in that, as well as issues around the judges and their permanent status. In addition, Honorable Speaker, I want to respond to the point around the number of judges, especially the appellate court that was raised by the honorable member from Southern Sudan.
It was the first instance.
Yeah. The reason that the Article 24(2) of the treaty that actually restricts the number of judges to that, and of course now we have more members than the 5 limitation that was given, and this is something that of course will be reviewed as part of the discussion that is ongoing around the treaty reviews. The issues of the bills that are passed by this House and the fact that within 3 months, some of them may not get returned is a valid concern. And I think it's something that we should ensure that it doesn't recur as it has been. But just as a way of background, the reason why this has been happening, Honorable Speaker, is that the summit has generally, as a practice, been assenting to bills collectively during the summit meetings. And of course, then the breach of the 3 months requirement happens often. And of course, customs and traditions will not override the provisions of the treaty and the rules. And the issues raised by honorable members is well noted, and we will take that up. On the issue of administrative and financial autonomy of the court, but also of EALA, this is something that is actively before the council, Honorable Speaker, and that the Secretariat has been tasked by the council to report back on the implication, especially on the financial front, of making sure that we comply with those decisions that councils have made in the past. That work is ongoing, and I think I will highlight when people talk about the council, what exactly that means. Because sometimes, council meets, and when meeting happen, decisions are not reached. For example, and I'll come back to that later, one of the things that I came for in addition to this meeting is for a council meeting, an extraordinary council meeting, which I have just learned that may not happen. And these are some of the real practical issues that actually stands on the way of decisions that needs to be made quickly. There are issues around salary increases of staff, which is very well noted. Of course, we must be, as an organization, consistent with what is happening in terms of adjusting for inflation and others. But we will make sure that these are all done in the context of some of the constraints that we have and the discussions that we will be looking at, because it is really, necessary. It is not necessarily a privilege that people should have. I think one of the things that the committee members forgot to include in the report is a meeting that I had with the president of the court, together with his team, where we discussed extensively issues around the court, included mostly within this report. And I took it personally as a commitment to get this to my colleagues in the council to make sure that we address some of the concerns that have been raised within the realm of the provisions of the treaty. I think the court decisions were also highlighted for not being obeyed. The specific case of Madam Ziwa was mentioned. All I would say is there is no excuse for court decisions not to be obeyed. Otherwise, we will undermine the essence for which the courts are put in place. But I can assure this House, Honorable Speaker, that when those kind of things don't happen, it is because...
Yes, honorable members, I see Honorable Kim wants to say something. Sorry for the interruption.
Okay, Honorable Speaker, motion. Honorable Speaker, I move motion on the Rule 30. Honorable Speaker, yeah, the Rule 30.
You can tell me the subject of the motion. I will help you to locate the rule.
I think the third one was Speaker is going to 1.
Yes.
So,
so you move.
yes.
You are moving for the extension of time?
Yes. So we have,
okay, because we are supposed to suspend at 1, and it's almost time, and we need to conclude this. So, Honorable Kim, relying on Rule 30 and Rule 11, wants us to extend a little bit so that we can conclude. Seconders, Honorable Gideon and Honorable Musamari and the others. Those in favor say aye. Those against say nay. The ayes have it. So we extend for as long as we need to conclude this particular item. Honorable Minister, proceed.
Honorable Speaker, for that. So I was talking about around the court decisions issues that needs to be obeyed. And I just want to assure the House that the decisions that are made by court must be and needs to be obeyed. And oftentimes things that delay some of those things to happen is because of lack of unanimous decisions that are required at the council. So we note, and as council, and I speak on behalf of my colleagues, that the report is very comprehensive, and I really want to thank the committee for that. And we will, as a council, study the recommendations with a view to implementing them that as outlined within this report. Honorable Speaker, I just then want to talk about the elephant in the room, the thing that normally undermines the ability for a lot of decisions to be executed within EAC. And that is about the treaty that we have that defines the rules and regulations of how we make our decisions within EAC. And I don't need to belabor the point other than to say that the treaty was established when there were only 3 members, and certain provisions and articles defining the specific activities are done bearing in mind that there were 3 members. But we've moved on. We now are talking about 6, possibly 7, and growing. And some of the provisions that are made there have become one of the biggest impediments of the council in particular to actually move and make decisions that are required of the council by the different organs of the community. You will be pleased to know, the Honorable Speaker and members, that we have started a process of reviewing the treaty and wanting to make a very speedy amendments to the treaty of EAC. You know, one of the challenges also, even to amend it, requires consensus. And so if there's no consensus, then you can imagine some of the challenges. And not only consensus, but everybody must be present. So I have taken the liberty as a chairman, as a chair of council, to actually informally engage with the CTC, the relevant people within the secretariat, to actually understand what are some of the key issues that we need to review. And as one of the honorable members alluded to earlier on, changing this treaty is no less important than it is changing a constitution of one of the partner states. And significant amount of engagement and stakeholder discussions is required. And it's with that in mind that, Honorable Speaker, I request to have a session one of these days with the Legal Rules Committee of this House to actually get their input on some of the things that are happening, that we need to change, that everybody needs to be on board in making things move forward. And just for just highlighting some of the things that we are exploring. For example, there is a need for us to recognize the French as a language of the community that is not big. Of course, Swahili and English is already provided for. The fact that, you know, the courts and EALA and others all require to be independent as they ought to be, to make sure that they can run their affairs objectively without interference from any of the other arms. The issues of financing has been a major bottleneck. You will be pleased to know, Honorable Speaker and members, that as we speak, there is a planned meeting that will be happening in Mombasa next week for finance ministers of the community to discuss some alternative financing program that will be making it easier for countries that have ability to pay more, but on a formula that is discussed and agreed. And I understand that significant number of members have already committed to that. There is probably 1 or 2 member states, probably 1 member state that is now consulting. And I hope that consultation, through the spirit of consensus, is concluded before the next 10 days when the meeting is going to happen. But on issues of quorum, issues of consensus, issues of sanctions must all be looked at to make sure that we are able to hold each arm of the community accountable, including the council. And it is important also to say that, you know, the process of changing this is as much political as it is anything else that people look at. There are doubts that could be there in people's minds on what it means if the 2/3 majority, for example, make a decision to move forward the activities of the council and of the community. And so everything that honorable members have talked about, council's inability to make things happen, to move things forward, to a large extent, is because either we have not all of us 100% agreed as a council, or indeed the meeting doesn't happen because all of us are not even available to attend. And so if there is one thing that we need to rally behind, all of us collectively, right from the Secretariat, the House, to the court, ministers of council, to the summit, is that we review and amend our treaty so that we deal with some of these bottlenecks that have really slowed down a lot of our activities going forward. With those many remarks, thank you very much, Honorable Chair, and we look for, Honorable Speaker, we look forward to getting this report formally and deliberate as a council on this. Thank you very much.
Thank you very much, Honorable Council Chair. Honorable Chair Kennedy.
Thank you so much, Right Honorable Speaker, and thank you so much, Honorable Chair Council, for responding to the request of the committee. Please, you are free to suggest a time and date that you would like to meet with the committee, and we shall be able to slot in and have a discussion with you at your time of convenience. I thank you so much. Right Honorable Speaker, I also want to thank all the members who contributed in enriching our report and giving in more inputs to what has been lacking in the report, or again, trying to emphasize some of the things that really we reported on. And we want to thank each and everyone and say that we did not take your inputs into granted and we are going to consider them. First, there were some suggestions from Honorable Makame. Please, the committee is gladly accepting those recommendations and we shall incorporate them in our report. Thank you so much. Suggestions from Honorable Order, please, we are going to do that and take that into consideration and make sure that we too have an activity so that we can be able to deeply look into the matters. With that, we have also scheduled an activity on trying to find out the status of implementation of our laws and protocols. And this is, it should be taking place between the month of either January or November. Times allow, we shall also give in a report onto that. With this, Right Honorable Speaker, I would like to thank the following members who have contributed to the debate. One is Honorable Dr. Abdullah Makame. Please, thank you so much. Honorable Gabriel Alak, Honorable Wanjiku Muhia, Honorable Kennedy, Honorable Umkiza, Honorable Kim Gai Rose, Honorable Francine, Honorable Dr. Oburu, Honorable Rosa Cole, Honorable James Kakoza, Honorable Order, Honorable Fancy, Honorable Susan, Honorable Dr. Ann Ito, Honorable Pamela, and lastly, the front bench and the Chair Council for such a reply to what the committee said. I thank you so much.
Thank you very much, Honorable Chair Kennedy Mukuria. Honorable members, I now propose them, put the question that the report of the Committee on Legal Rules and Privileges on the oversight activity on the development of the legal sector in the East African community be adopted. Those in favor say aye. Those against say nay. The ayes have it. I also want to join you to thank the committee under the chairmanship of Honorable Kennedy for a very good work and a very good report. I think the amount of support it got is self-evident that the committee did a very good work. So before I suspend, I want to make two housekeeping arrangements so that I don't forget. First of all, Honorable Kennedy Karonzo has been insisting that his committee, accounts committee, wants to meet with the council chair. Now, when we look at our program, we may not have time for the committee to meet with the council chair without inconveniencing the activities of the assembly in terms of plenary. So I suggested to him, but I want to have a consent of committee colleagues that whatever you wanted to get from the council chair could be submitted in writing. Can it work for the committee? It is about the audited accounts. So the issues that the council needed to clarify can be submitted to the committee in writing. That is more practical. Is that okay? And if it is not, then you should be ready to tell me when can the committee meet the council chair without affecting the program of the plenary. Maybe you need time to reflect on that. You don't have to respond now. Some of us have been training. And I think those who have been to the training grounds, you have seen how important it is. We know that on the first and second day, when you have not been in training, it can be painful the following morning. But the remedy to that is to be consistent and go there again. So we are in the process of negotiating the budget for the interparliamentary games. We must demonstrate that we are serious with the games, because you can't plan to have games when you are not practicing or you're not training. So I don't know when the next program is, whether it is evening or tomorrow, Honorable Susan. Evening, please be there. It's good, it's fun. Even, we will not be going there to compete as such, but we need to be fit for our own benefits. So on those remarks, suspend the House until 2:30 in the afternoon. House is suspended. Good afternoon, honorable members, and welcome back. Yes, can we proceed?
Item number 4 on the order paper, report of the Committee on Regional Affairs and Conflict Resolution on the implementation of the EAC Peace and Security Strategy. By way of a motion.
Honorable Chair, Committee on Regional Affairs and Conflict Resolution.
Motion, right, Honorable Speaker.
Yes, Honorable Dennis.
Thank you very much, right, Honorable Speaker. And honorable members, I would like to move a motion under Rule 30I, which is a motion without notice. Which says, Rule 30, the following motion may be moved without notice. I, any motion on an urgent matter of public importance, supported by 1/3 of the members present. That's Honorable Speaker.
Yes, before I ask for the motion to be moved and seconded, maybe can I have an idea of what the motion is about? It's just giving me the idea, not moving the motion.
Yeah, right, Honorable Speaker, indeed, as I've said, under Rule 30I, it is a motion of on urgent matters of public importance to the community. And this is in regard to the exercise taking place of recruitment of the members of staff of the East African community, which we regard to be a very, very serious issue and which touches on our core functionality as a parliament.
I think you meant L, not I. Isn't it?
30, yes, I think AK, IJK, L, yes.
Yes, now because the speaker has to rule whether the motion can be moved under this rule or under the rule that requires notice, let me have the idea about the urgency that is involved in it.
Right, Honorable Speaker, so I would have to justify the motion before
it's not a justification.
I read it, or?
It's not a justification. It is giving the minimum information that would help.
Right, Honorable Speaker, as you're aware that the recruitment is going on, and that the recruitment is going on as members of parliament, we feel that there is total breach of the provisions of the treaty and other legislations of the community regarding how recruitment should be undertaken. And we feel that is a very important matter, because if we don't debate on it, and yet the process is ongoing as we talk, it will bring a miscarriage of justice to the people of East Africa.
Do you have it written, or you will just move it to verbally?
I have it right on the speaker.
Have you distributed copies?
Yes.
Do you have copies?
Yes, we have right on the speaker.
Okay, if you, let's distribute copies first. Does everyone have the copy? Okay, Honorable Dennis, you can move your motion. You can move so that it gets seconded.
Thank you, Honorable Speaker. I beg to move a motion under Rule 30 L of our rules of procedure, which is a motion without notice, and read that the motion for resolution of the Assembly recommending to the Council of Ministers to suspend and audit the ongoing staff recruitment exercise due to the irregularities and unfair treatment of the citizens from Burundi, Rwanda, South Sudan, and Uganda. I beg to move that.
Seconders. Honorable Kim Gai, Honorable Guy Deng, Honorable Musamali, Honorable Alak, and all members standing. Now, before you proceed, Honorable Dennis, there is something I want to verify and put on record with you so that the process can become as fair as possible. I spoke to one of the diplomats in the region after I had heard information about this same issue, because you know it's been a subject of discussion for some days, even if it wasn't yet on the floor of the House. So I wanted to verify from one diplomat in the region on the allegation he had raised with a certain authority that the speaker himself could be biased against the state of Uganda. And indeed, he confirmed to me that he had said that. So although it is not, I'm not compelled under any rule, first of all, to raise this with you because it is something that happened outside the House. But throughout my career, I have applied the standard of Caesar's wife. You know the Caesar's wife standard, that she should be beyond suspicion. So, Honorable Dennis, based on that, do you confirm or not that if I presided over this exercise, it will be treated fairly, or I can apply Rule 41, where you can have somebody else handle this, and possibly, depending on how the process evolves, I can also have an opportunity to say something. So it is up to you to decide. Can I give you the opportunity for another member to preside? Because the diplomat told me, Speaker, we are told by some members that you are biased against the state of Uganda. It's not about the reasons or whether it was justified or not. But because that was raised with me, I don't want to preside over a process where some people, even if it is one, they would feel that they are not fairly treated.
Thank you very much, Right Honorable Speaker. Number one, the motion is not only about Uganda, that's for sure. It's about the other partner states, that is the Republic of Burundi, Republic of Rwanda, Republic of South Sudan, and Uganda. So I do not think that in my mind, as a speaker presiding over, that you can sway the debate in any way because of you presiding over, that you are biased or you're not biased. I wouldn't like to confirm or deny those allegations because I'm not in a position to do so, as it was a discussion between you and the diplomat.
It was a discussion between me and the ambassador, Kabonero, Richard Kabonero. So, but if you're comfortable, I can proceed.
We're okay, Right Honorable.
Yeah, I asked him whether indeed he had alleged, that I'm biased. And he said, yes, I heard this. Now it's not whether he believed it or not, but even the fact of alleging, for me, is a serious matter. Yeah? But if you are comfortable, fine. If you are not comfortable, one of you can proceed.
Further clarification, Speaker.
Information.
Thank you.
Sorry, Honorable Musamari.
Yes, thank you, Right Honourable Speaker. From the onset, we have you have presided over this house for the last 4 years, coming to 4 years. It's coming to 4 years. So far, we have not seen that level of biasness. And another thing, and this one came from you, when we were having an informal meeting where the Ambassador Kabonero was and where you were, you indicated, the two of you, you indicated to us that you are very, very close friends. So now, Right Honourable Speaker, I don't know whether Ambassador Kabonero could have had some other reasons, maybe because of your closeness, but not because of this. So I believe that basing on the experience and the practice, you will still preside over this house freely and fairly. And lastly, it will even give you opportunity now not to be associated with any level of biasness. Right, Honourable Speaker. I thank you.
Well, I don't need, yes, to be associated, fine. I thought you would say, I thought you were saying it gives you the opportunity not to be biased. But now we can end that, honestly, and I want to confirm that the ambassador is a good friend of mine. But when I heard about that, I didn't want to take it lightly. I wanted to be sure about it. And indeed, he was very frank with me. You know, I heard this story, and the only thing I thought he hadn't gone right is not raising it with me directly. But fine, if this house still has confidence that I can preside over this debate fairly, then Honorable Namara, you can proceed. And let me clarify another issue. Honorable members, please. This was my issue that I raised, and I think we are fixed. We are done with it. Another issue, and why I'm allowing this motion, and not the other one, the other petition I got before. Let me also clarify that. There is, I think, a huge difference between this one, the way I can see it, and the other petition. If you will require that I clarify later, I can clarify. So, Honorable Order, are you insisting?
Yes. Clarification, Speaker, on the procedure. I'm not sure if I was supposed to come later after my colleague has presented this, but I have seen my country being mentioned here on this motion while I was not consulted. So I wanted to be sure if this is something which was procedurally how it is supposed to be done, so that I can be able to give my inputs on this before it goes on another step.
Well, first of all, let us understand the rule, and you will help me to interpret, because there are certain things we can resolve during the debate. First of all, this, when you move a rule without notice, a motion without notice, this requirement of how much the support should be how much? 1/3. Is it a support needed for the motion to proceed? To do what?
1/3 to approve, Honourable Speaker.
For the motion to proceed on the floor.
To pass. To pass.
To pass?
Yes, but the motion must be seconded only.
It is to proceed.
No, to approve.
To pass would be the usual way we pass motions. It would be an aye and a nay. So this threshold is the one required for the motion to be entertained under this rule. By the way, it is not a threshold required for the motion to be entertained at all. No, it is for the motion to be entertained without notice, meaning it can meet or not meet the threshold, but it still would come under a different rule where that threshold is not required. Are we together in terms of interpretation? Yes. When you move a motion without notice, you are in principle interrupting the business of the House. So that is where you require that number to allow you to do that interruption based on how you have convinced. But it doesn't cause the motion to collapse. It leaves the room for the motion to come again with notice. That is the point. So let's go procedurally. You have heard the motion that Honorable Namara moved, and it has been seconded. Let me know, and the sergeant will be involved.
Procedure, Mr. Speaker.
let me know how many members will allow it to happen.
Procedure, Mr. Speaker.
Yes, Honorable Msamali.
Thank you, Mr. Speaker. As you proceed with the sergeant probably to ascertain the numbers and the threshold, I rise on two issues here. One, in terms of practice, we have had many motions of this nature, right, Honorable Speaker, and you have never referred to that rule and to that counting. That means that if we are to go by practice, we will still go ahead and allow this motion. The second thing, given what you have just said, that surrounds that so-called controversy, I'm of a view that we proceed and move that motion, and then we go ahead with the debate in line with the practice.
Actually, Honorable Msamali, I don't like the idea of referring to that because that sounds like a blackmail and it is not in order. And there are rules that protect me as the speaker, by the way, despite the humility. So don't make reference to that thing again.
Further procedure.
Yes. So procedure, Honorable Susan.
Honorable Speaker, if in your wisdom there is an issue with Rule 30, we can still proceed under Rule 13.
Rule 1.3.
Yes, which says a member may at any time, for reasons stated, seek leave to move that the House do now adjourn to debate a matter of urgent public importance. So the motion on the floor to some of us is of urgent public importance in the region. So I don't see a reason why the member should not be given time to move under any of those rules. At least justice should be administered without undue regard to technicalities. Let's put aside the technicalities and have the substance heard. Thank you.
Yeah, but honorable members, don't you think it is in the best interest of this House to have these matters, some of them in open, instead of, what do you think, members? You know, because you know when members, things continue going around like this. Is there a problem with that? Is there a problem? Is there anything we are hiding? Sorry?
Right, Honorable Speaker, I think there is no problem, but because we are a house of rules, let's follow the rules. So if
Can anyone address me under Rule 13? Now let me operate like judges in the Commonwealth who really challenge parties to be the ones to address the judges. What is your understanding of Rule 13? Anyone who can help me?
Well, proceed, Honorable Speaker.
I think when I seek something, please allow me time to pick the path that I think will help me. Now, Rule 13. Can you consider both 13 and 30? Can anybody say anything about Rule 13?
Procedure, right, Honorable Speaker, if you could allow me, sir. As a way of moving forward, right, Honorable. I believe, right, Honorable, that as a move of the motion, we have the number. We have 1/3 of the members present from the time I moved the motion. Because I moved the motion, now by the time when I moved it, to ascertain the number that is there.
We are not talking about the quorum of the House.
No, I mean the motion, the 1/3 of the members present.
Information.
Yes.
Information.
Is what is required 1/3 of the members present in the House?
Yes.
Information.
Or members supporting that
Yes, the members can stand up.
No, listen, Honorable Namara, can you resume your seat? It is 1/3 of the members required to support the motion.
Information.
It is not 1/3 of members present in the House.
Information, right, Honorable.
Because that would mean we are ascertaining the quorum of the House.
Information.
Listen, honorable members, you know, let's switch off your microphone, all of you. If we are not careful, we are going to create a scene in the house. And it is not going to be helpful to anybody. It is not going to be helpful to anybody. So we need to be sober about this. This is something that can slip easily out of our hands, and it becomes an issue between partner states. It can cease to be an issue between members discussing the matter that concerns the House and the community, and it can become an issue between the partner states. I don't think at this moment in time, in our tour of duty, I don't think anybody needs that. I'm just trying to caution you. I really don't think anybody needs that kind of a scenario. Because what I can see, the signs I can see, is there is a real risk of emotions going very high and the situation is slipping out of our hands. So let us be orderly. Let us be orderly. We are reading from the same book of our rules. We are interpreting together. Let's agree on the way forward without emotions. Honorable Namara, you moved the emotion without notice. Let me hear from you as a lawyer and as a member. What do you think are the conditions for that kind of emotion to proceed? Yourself.
Thank you, Right Honorable Speaker. From the rule, I can read it. Any motion on urgent matters of public importance supported by 1/3 of the members present.
Now, how do you understand that?
So my
provision?
understanding is, Right Honorable Speaker, that since it's a motion without notice, it means it's not written. It means that if my motion members who are here, 1/3 of them who are present, of the entire members who are here, 1/3 of them can support my motion, then my motion passes. Right Honorable.
Yeah, so at what time do you think that support is sought?
At this time, Right Honorable.
Yes.
Yes.
So we are together.
Yes.
So how many members do we have in the house?
Procedure.
No, Honorable, please. Honorable Namara, we are together in terms of how you are interpreting. If you have 1/3 supporting, we proceed. So how many members do we have? First, Sergeant. And please, all of you switch off your microphones. So how many members supported that we proceed? Yes. So how many is 1/3? So do we have the required threshold to proceed? Yes. That is 1. So we'll proceed. 2. Honorable Namara, you may need a minute or 2 to read some of the rules here. And please bear with me because it is a very delicate exercise we are conducting. (45). Don't read aloud, just have it in mind. So you can proceed.
Procedure, Honorable Speaker.
Thank you, Honorable Speaker.
Thank you, Honorable Speaker. The mover of the motion have indicated that a motion of public interest. I'm interested to know which public and how can we measure the public interest in this matter?
Because that is something we were supposed to ascertain when we are looking at how many are supporting.
Honorable Speaker, I
yes.
raised and you said we switch off our mic.
Unfortunately, I didn't see you. But I was hoping that when you were deciding whether to support that the motion proceeds or not, that is the matter that one had to consider. Are we together? And in any case, we are the ones that will make a decision here after we hear the details about it. And I have reminded the mover about the rules of the House that he needs to observe. So you can proceed.
Thank you very much, Honorable Speaker. Moving under Articles 49(2)D, 59, one of the treaty, and Rule 30 of the Rules of Procedure of the Assembly. Whereas Articles 45, 48(4), 66(2)D, and 7 of the treaty provide for the appointment by the Council of such staff as required for the proper functioning of the organs and institutions of the community. Whereas Article 14(3)G of the treaty requires the Council to make staff rules and regulations, and in 2006, the Council duly issued the current staff rules and regulations, which according to Regulation 1.1 embody and define the fundamental conditions of service and the basic rights, duties, and obligations of staff, and laid down the general principles for human resource management in the community. And whereas on the 7th of May, 2021, the Council at its 42nd extraordinary meeting directed the Secretariat to commence recruitment for various positions in the organs and institutions of the community and establish a panel to conduct the recruitment in accordance with the staff rules and regulations issued by the Council. Recognizing that in establishing the panel to conduct the recruitment, the Council was and has always been mindful of the provisions of the staff rules and regulations on recruitment and appointment of the staff. And did not give.
Honorable Namara, when it is a point of procedure, I always have to listen.
Sorry, Mr. Speaker, we have no quorum. If you look in the census of Tanzania, we have only 2 members.
Can the sergeant ascertain quorum? Do we need to look into the entire composition, or we just look at the chapter that is spoken about?
Right, Honorable Speaker, we are only 2 in the House. We don't have a quorum.
Okay, the sergeant will ascertain the quorum. Honorable Susan, please. I think you can be fast. See, when there are more than 3, we proceed. Yes. So there are only 2 members from the United Republic of Tanzania. According to our rules, we suspend for how many minutes? 15 minutes. We'll be back here to ascertain the quorum after 15 minutes. I think now we shall ascertain quorum based on the chapter that was lacking quorum. Is that the simplest procedure? We check everybody. Okay, Sergeant, chapter by chapter. Just to see if we have 3 members. We have 2 members from URT. Call all the chapters by them. Call all of them. So, huh? Okay. So now, honorable members, as you can see, we have only 2 members from the URT. In the end, our rules, that means we don't have quorum. Let me consult the clerk shortly. So, honorable members, for lack of quorum, we cannot proceed. And according to our program, tomorrow we don't start in the morning, it is at 2:30. So I'm adjourning the house until tomorrow at 2:30.